Kotal 19. Raghu sir. Sir, ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಮೇಡಮ್ ಕೇಳಿಸ್ತಿದೆ.
ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ಲ?
ಹಾ, ಕ್ಲಿಯರ್ ಇದೆ. ಥ್ಯಾಂಕ್ ಯು. Court officer. Madam, serial number 15 ಯಾವ page madam?
15 page number 4 sir.
Page wise ಅಲ್ಲ ನೀವು ಕರೆಯೋದು adjournment ಗೆ? Thank you madam.
Court officer CCH 19 Court officer
Kumaras. Two 32. Then tomorrow we will do. Tomorrow we will do. Tomorrow we will. 30. 1:30 if possible. The files has come 1:30.
Serial number 15, my lord.
Just 1 minute. Tomorrow. 1:30. 1:30. Tomorrow. Huh. Let us, I will verify. I'll verify, madam. I will verify the file.
Serial number 8 to 10. Any appointments in serial number 8 to 10? Serial number 14 to 22?
Serial number 15, my lord.
15, sir?
Yes, my lord. May I request it to be taken up on 28, my lord?
No, no. The request made by the Rana Council appearing for the petition list after 2 weeks. Let us wait.
My lords, serial number 22, my lords. Serial number 22.
22.
My lords, I
your-
appear for respondent number 3. I seek 2 weeks time to file my objections. I have informed the learned counsel for the petitioner.
The request made by the Rana Council appearing for the respondent number 3 list after 2 weeks.
Please.
Serial number 23. Serial number 23. Serial number 24 to 31.
My lords, one submission, my lords. In pertaining to number 28 to 35, my lordship had given me to Mr. Mr.
28 to 30.
My lords, Mr. Nanjan Reddy is appearing in the matter. He's not in town. He's requested me for tomorrow, my lords. He's not in town today. My lords, he's not in town today. Tomorrow,
Last time also they, last time
my lords,
also.
that is because first time I had appeared, my lords, on the last Tuesday it had come. First time I had appeared. My
Yes,
lords,
tomorrow some other matters will be there.
they have, my lords, it's a short matter only, my lords, my request. Otherwise, day after tomorrow, Wednesday, my lords.
No, day after tomorrow also, see, every day we have some matters.
He's not
Exclusively I
in
will-
town, my lords. That's the reason. My apologies. He's not in town. He requested me tomorrow, my lords.
No, no. No, no, tomorrow we will take it. 2:30 we will. 2:30. 28 to
35, my lords.
35.
Please.
Yes. 28 to 35 tomorrow. Tomorrow at 2. I think after preliminary it will be taken.
Please,
After preliminary it will be taken.
please, please.
It's very. I let us wait. After preliminary it will be taken tomorrow.
Great
Yes.
for them.
Yes.
Serial number 36 to 40. Serial number 40.
Today. We will close this matter. Court notice. Court notice. Court notice issued by this court by order dated 27/9/2022. Written with Shara, comma, noted, comma, item return, addressee, mood, comma, insufficient address. Close the email. No representation has been made even today. Accordingly, the petition is dismissed for non-prosecution. However, it is open for the petitioner to for an application seeking recall the order. So advise if so advised. Yes. What is this rectification of circle? Give one more copy. Give one more copy. And rank of the party is not correct. To comply with the officer. Then a counsel appearing for the impleading applicant. Then a counsel appearing for the impleading applicant seeks 2 weeks time to comply with the officer. Interim order granted earlier, extended till next step. Non-compliance. What is this officer? Comply ಮಾಡಿದ್ರೆ. For the by the same person, by the same petition. You have a copy of the same. Whether you have a copy of the same, please pass. So order dated 22/9/21 by the Director of Primary Education. How can you file, sir? How can you file? One minute. Today it is. No, not correct, sir. Not correct. No, it should be dismissed with cause. Very well. So, no. Hardilana counsel appearing for the parties. Leonard, Madam so and so, Leonard AGA, brought to the notice of the court that the petitioner institution has filed a revision petition number 49 of 2021, challenging the very same order dated 22/9/2021, passed by the appellate authority in appeal number 1 of 2022. Before this, yes, 1 minute. But that is appeal number 1 of 2020. Just 1 minute, 1 minute. Correct. Now the revision petition is filed. Revision is pending against the order dated in appeal number 1 of 2020. This is appeal number 3 of 2007. 1 minute. No, whether that is against appeal number 3 of 2017. See, no, here, no, why I'm saying the first prayer in the appeal, in the revision, he set aside the ordered appeal number 1 of 2020. Just look at the prayer in the writ petition. That is appeal number 3 of 2017. That is 1 of 17. 1 of 2020. No, in the writ petition, appeal number 3 of 17. Prayer, just. Yes. In appeal number In appeal number 270. Just 1 minute. No, they made corrections. They made corrections actually, yes, wrongly. Annexure, go to Annexure A. No, appeal order. You see, appeal, it is not 1 of 2020, it's 3 of 17. Correct. Now it is, now they have made correction. Totally. You pursue revision petition, better. Pursue. Yes. But the petition hearing has challenged the appeal number 3 of 2017 in revision petition number 49 of 2021, which is pending consideration before the principal secretary to government, primary and secondary education, Bengaluru. That was the matter. I'm of the view that petitioner cannot pursue two remedies simultaneously, and in that way of the matter, reserving liberty to the petitioner to pursue the revision petition number 49 of 2021, the present writ petition is dismissed as withdrawn. Yes. Who is R5? Third. Yes, third. It is third. It is submitted by the Lana Council appearing for the petitioner that the election to the respondent number 5 society was concluded on 23/4/2022, and the petitioners casted their vote. Full stop. In that way of the matter, I'm of the view that no further orders required to be made in this petition. However, the aggrieved party liberty is reserved to the aggrieved parties to challenge the election process, challenge before the competent tribunal. If so agreed by the outcome of the result in the scheduled election held on 23/4/2020. You have fine? You are applying for the petition. Sir, copy. Not sir. Then a council applying for the petition submitted. So you have to comply with the office objection bit. Then a council applying for the petitioner is yes. Then a council applying for the petition is permitted to comply with the office objection within 2 weeks. No, next week. To comply with the office objection, move it 1 week. Yes, what is this? Just 1 minute. 1 minute. No, ITI is not. I think ITI is the relevant. Annexure A. Which college, sir? Let us will see what the college will say. Let us see what the college will say. Well, no. You approach the court, but let us will see what the college will say. In the event, in the event if the college refuses, then only the cause of action. Correct. Degree certificate. Yes, sir. That's all. Next year. That is 10 plus 2 plus. No, next year is a BA degree examination. Then the college will. Yes. On direction, they will look into the marks card and consider your admission. If it is 10 plus 2 plus 3, which is the regulation you have. You have a copy of this. Just a minute. Sir. Regulation 5 of the KSLU. No, anyway, you produce all these things, let the college will consider. No, college has to consider. Yes. Eligibility certificate from the. Eligible certificate, how can the university? No, first you have to get admission to the college, from college to the university. That is the. Third, Sri Narendra Gowda, Lana Council appearing for the petitioner, and Sri Ganapati Bhatt, Lana Council appearing for the respondent university. It is the case of the petitioner that petitioner is eligible for admission to 3-year LLB course of the respondent university, and as such, the petitioner has made an application to the two colleges, namely C. Bhimsen Rao National College of Law, Shivamogga, and Sri Sharda School of Law, Chikmagalur. Having heard the Lana Council appearing for the practice, there is no impediment for the colleges, the aforementioned colleges to admit the petitioner hearing if the petitioner hearing, is having the eligibility criteria of 10 plus 2 plus 3 as stated in the regulation 5 of Karnataka State Law University regulations. If the petitioner is complied with the same, the colleges, the aforementioned colleges shall admit the petitioner and forward the same to the university for approval. That's it is also made clear that the petitioner hearing shall provide the relevant documents, namely the SSSLC certificate and the pre-university marks card to establish that he has passed the 10 plus 2 course also. That is clear. Yes, correct. So you provide that they will admit you. Yes, sir. Yelly, where is that? Page 5. That is 10 plus 2 plus 3. Anyway, regulation 5 provides for that. That's all.
I'm saying you are entitled to
That's all. Plus 3 you pay. So it covers the eligibility criteria mentioned in regulation 5. He will be admitted. Next matter. That way of the matter, comma, writ petition is disposed of. Yes. Yes. Yes, sir. Yes, sir. No, it is disposed of. It will be released. Today itself, it will be released. Very good.
My lord, I appear for the petitioner. This is the case. This is the case where, my lord, your lordship had dismissed the writ petition on the ground of delay, and there was some doubt, my lord, regarding signature, my lord, which I have produced, my lord, annexure B. Annexure B is a document, my lord, signed by the petitioner as well as the guide, including the co-guide. Page 29.
But the objection filed by the respondent university state that the aforementioned 2 guides have not approved.
Annexure G may kindly be seen, my lord. Annexure G. This is a email communication whereby.
Yes, sir.
It's the email communication whereby they affirm their signature.
Yes.
It is. They have not said that don't.
They have informed the university.
Yes, my lord.
But
even before they have informed the university, the language may be little not very happily worded by them, but the fact remains, my lord, they have signed the document, and it is only a question of.
You sir, copy to.
Yes, my lord. Santosh Nagar.
Yes, Santosh. Sorry. Then a counsel applying for the petition is permitted to serve copy of the review petition to the counsel representing the respondent number 1 and 2 dash Shri Santosh S. Nagarani, panel counsel for the respondent. Let us view it.
Highly obliged, madam.
To PUC agreement, how can it? That is no, that it should be 10 plus 2 plus 3. That is there in the regulation. No. Yes. Yes. You comply with the regulation 5, get it admission. That's what I made. 10 plus 2 plus 10 plus 2 plus 3. That is regulation 5 of the KSLU. That's direction. If it is done, it will be taken. 10 plus 2 plus 3 is the criteria, sir. ನಾವೆಲ್ಲರೂ ಓದಿರೋದು ನೀವು ಓದಿರೋದು ಅದೇನೆ. That's all I would say. 10 plus 2 plus all of us have studied very same. That is also I have stated regulation 5.
Yes, they are making.
No, not that is 10 plus 2 plus 3 complied with will be. That's the law. ನೀವು ನಾವು ಇಬ್ರು ಓದಿರೋದು ಒಂದೇನೆ. 10 plus 2 plus 3. Next matter. 8. Same order. ಮೂರನೇ ಸಾರಿ ಬಂದಿರೋದು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. What is this matter? Yes, sir. What is your challenge? Yes, sir. Pass for me. Order 7, pass.
Number 9.
Notice. Sir, copy. You take note. Yes, correct. It is a sixth respondent. Diploma. Third semester. You take notice. You take, let sir copy, let us. Huh? 20? Today's matter. 20? Yes, sir. Yes. No, sir, copy, let us. Yes. You, sir, copy to the other side, let us. Yes, very well. By that time, so Leonard AG accept notice for respondent number 1 to 3. 1 to 3. VTU Santosh Nagrale accept notice for respondent number 4. She NK Ramesh, when a council appearing for accept notice for respondent number 5. What about AACT? Mr. Shauri accept notice for respondent 6. Issue emergent notice to respond number 7. 21. Thus, list on Thursday. List on Thursday in preliminary. Yes. 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 Yes, sir. Yes. Oh. Because no, only thing is already notice has been served to him. Because in page 40, reasons is given. Yes. The vacating application was. Yes. Third is. Leonard AG accept notice for respond number 1 to 3. Issue emergent notice to respond number 4. Stay of further proceedings in ER 32/ETC case /CR-28 interim prayer. Stay as prayed for. Yes. Yes, sir. Yes, sir.
Saying that there is this one.
At least implementing application.
Actually, the pending application is now filed by Shimoga Military. Our consequence of the
Better. Friday, Thursday, please. Thursday.
My friend
All for the meeting. Okay. Just Wednesday, sir. Wednesday. Nadidu.
24th or 25th today.
All of you just right. Immediately after preliminary it. No, it will be heard. No. Within understanding that it will be taken up on Friday after preliminary. Let us anyway, Friday it will be taken. By the time so that you can file. Please complete it. Complete. Yes. Then a senior counsel, Shri Kumar S. Patil, submitted that in view of the IA 3 of 22 filed by the respondent society seeking vacating the interim order, then a senior counsel seeks short accommodation to file necessary pleadings before the court. This matter on Friday today. You can understand it will be taken up. Both 11 and 12. Just 1 minute. Manda District Central Cooperative. Correct. When it will be taken up? No, it's other matters. The request made by the council appealing for the petitioner. Next week we have something. To list after 2 weeks for Monday. Yes, 5th without pay. Interim order granted earlier, extended till next of year. Yes, I think it was heard actually. Yes, heard. Yes, yes. Only on that aspect. Anyway, it is substantial. It is hard. No, even otherwise, for maintainability, just you can complete the procedure, complete the arguments.
Irrespective of what the observations are to get first. Another one.
Yes. Anyway, it is substantially hard, sir. So that. Hard. Address there. Before Monday, sir. How one day kaid madbodu. Everything is in your. So 2:30 ante put it. So yes, told you. The request made by Lana senior counsel Sri Kumar. This on Monday at 2:30. Interim order granted earlier. Excellent list. Part of this. Part heard in part of the furthering on 2:30. Furthering on 2:30. Yes.
I appear for respondent 3, Your Lordship.
Yes, sir. Kiran CV.
Yes, sir. Yes, Your Lord.
Kiran CV is for R3. Just 1 minute.
The
Just
remaining council's name may be removed, Your Lordship, like Krishna, and it is also reflecting.
yes, sir.
Ramanjanagoda University of Kolkata have filed.
Good evening. Connected matter. 439. 16. Yes. 60. What has happened now? Just a minute. That's good. Yes, very well. Very well. 1922 ನಲ್ಲಿ ಇದೆಯಾ? Where is the applications? application.
That was filed on 29 September 2020.
Please give me your application. Yes. That's it. Heard the Lana Council appearing for the parties. Having taken note of the heard the Lana Council appearing for the parties on IA 1 of 22 filed by the Lana Council appearing for the petitioner seeking extension of the interim order dated 2/1/2018 in it is in GNWC. In GNWC number 214 of 2011 on the file of the second additional principal family judge Bengaluru. Or the Lana Council appearing for the parties and taking into consideration the actual aspects of the case as and this court 18/8 alla? Huh? 16 1 minute. It's not in the order sheet. Which order sheets? Bopana Sahib, having taken note of the factual aspects, the order dated 16/1/2018 is extended until further orders. Yes, sir. Yes. List after 8 weeks.
Lakshmi, the other council's name may be removed.
Previous matter, it's serial number 15 only. Yeah? Your name has to be. You are appearing, sir. Kiran CV.
Kiran CV.
Previous idralli registry is directed to delete the name of Sri K. Krishna for respond number 3 and Sri M.N. Ramanjaniya Gowda for respond number 3 and retain the name of Sri Kiran CV appearing for the respond number 3. Yes. Yes, sir. Pass out. Fifth respondents. Pass it to me.
Umesh Parashuram.
My lord, appear for siege against kindly it may be taken at 2:30, my lord, with physically.
Question the order dated respond number social. The next shall be is challenge, sir. 4D, section 4D. No representation on behalf of the petition. List after 2 weeks. In order to provide an opportunity to the petitioner, petitioner list this matter next week. Lana Council appearing for the respond number 5 is present. Yes. Yes, madam. Yes, yes. Correct. So appeal is there. Appeal is there. When a council appearing for the petitioner, the petitioner is seeking following reliefs. When a council appearing for first step, no representation on behalf of the petitioner today also. The petitioner has not represented the matter on the last occasion on 16/11/2022. This court has granted an opportunity for the petitioner to make submission in this matter. Having full stop. Full stop. Then the AGA submitted that the impugned order is passed under section 68 of the Karnataka Cooperative Societies Act 1959. And the of the same petitioner is having efficacious remedy in appeal under the act, and in that of the matter, the petition is accordingly dismissed as not maintainable, reserving liberty to the petitioner to exhaust the alternative remedy provided under the act. Yes.
Appearing for the response.
Yes.
Appearing for the respondent university, Your Lordship. Your Lordship, this matter was connected.
Just 1 minute.
Yes.
1 minute.
Yes.
Just put it in. Here, what is which course this matter? In your matter, which is the course? Oh, that is AICT there. Maybe disconnected. So,
Your Lordship, in both the cases, I mean, I understand that AICT is involved in one matter, while in the other it is not. But however, Your Lordship, both the courses that are in subject of this dispute before this honorable court are technical courses, and insofar as in both the situations, I am tied up by the same notification. Therefore,
maybe anyway, the AICT is not a party here. So disconnect this and let us will hear that matter separate. Better.
Very well, Your Lordship. Very well, Your Lordship.
20.1, it is submitted by the Learner Council appealing for repeated parties that 20.1 be disconnected from WP number 15868 of 2020. Accordingly, same is dealing. Yes. What is this matter? 20. Yes. Just a minute. 2008 to 2011. Which course? Lecture change. I think up to I think some year it was recognized. Which is that? Annexure? Yes. So she has secured BSc animation from the Open University. I think there's one the circular issued by the UGC, which is that? '11 batch. Yes. Yes.
University did that, the application for the competition. But your advice is something to make. Same course batchmates have got when the batchmates had
Take it. What about the similarly placed students? Where is that? Where is that? Sorry. Where is it? Ah, 8-4. Just what I'm reading. R10. In accordance with R10 that they can consider. Annexure R10. Even that they have also produced. 8-4-20.
May I submit, Your Lordship?
Just 1 minute. The same. R10 and whatever that you now you have filed is one and the same.
Yes, Your Lordship.
Document number 1 and the R10 is filed by the respondent is one and the same.
It was attached to 2008 to 2011. Which month?
Now only that the convocation certificate and the relevant marks card has to be issued. Yes.
Your Lordship, subsequent to R10, Your Lordship, on 8/4/2021, the university definitely took a decision that they would want to proceed with giving convocation certificates to the students who are enrolled through affiliated institutions also. However, Your Lordship, on R11, Your Lordship, if Your Lordship may kindly peruse R11, on 18/8/2021, a letter was received by the university from the UGC, in which, yes, Your Lordship, if I may kindly seek Your Lordship's indulgence to page 33 of the statement of objections, last 2 paragraphs, Your Lordship.
Yes.
The UGC has issued a detailed public notice dated 27/6/2013 with regards to the territorial jurisdiction of the universities for offering distance education program and other matters related to distance education in UGC website. The public notice dated 27/6/2013 was only reiteration of the earlier policy of UGC on territorial jurisdiction of the universities. Therefore, Karnataka State Open University is directed not to issue any degree to the years for which the university was not recognized or territorial jurisdiction has not been complied. If any violation is noticed, punitive action shall be initiated against the university. It is this letter, Your Lordship, this particular case, the student had enrolled in 2008. However, due to a backlog, the examination, he cleared his examination only in 2013. Therefore, Your Lordship, it falls within the years of beyond 2012 and there was a confusion with the university whether it has to proceed issuing the certificate or not. In the meanwhile, the university conducted an academic council meeting, approval of the governor and the state government, and issued a circular also, which is produced as R10, in order to proceed with issuing the degree certificate. At that point of time, UGC has stopped us from issuing. We have been directed by the UGC. If that can be overcome, Your Lordship, the university will only perform as directed by this Honorable Court.
But insofar as other students that have already issued.
In all fairness, I must submit, Your Lordship, insofar as the other students who had completed between 2008 and 12, the certificates had been issued. There are some students who do carry the certificate and the degree certificate. And if I may, Your Lordship, I must also add to my detriment, however, that so far as those issuance, those degree certificates are concerned, this also must be brought to the notice of this Honorable Court, to my detriment, very frankly speaking.
Of course, if you treat the petitioner as of insofar as other students in which that you have issued.
I am only before this Honorable Court, so I will perform as directed, provided UGC, because I feel I am in between the petitioners and the UGC. If I issue the certificate, punitive action is likely to be taken by the UGC. So if this Honorable Court may direct,
already
then
insofar as it's a 2008 and 11 batch. I think similarly placed the student that already issued the convocation certificate. So issue that let there be a direction. Let there be a direction.
Very well, Your Lordship. If Your Lordship may direct.
Yes, sir. It's the grievance of the petitioner that the respondent 3 university has not issued the degree certificate, 4 sets of transcripts of marks cards, and the migration certificate, after the completion of BSc animation for the batch 2008-2011. It is stated in the writ petition that petitioner was admitted to third respondent university for the course Academy of Animation and Gaming AAG-Toon School, Noida, India 2008 for 6 semesters BSc Animation course. It is stated that the petitioner had appeared for a 6th semester examination conducted by the third respondent university in the year 2011, and thereafter she made an application to the respondent university seeking degree certificate. However, it was communicated to the petitioner that he had failed in one paper of the 2nd semester, and in order to complete the said course, the petitioner had appeared in the supplementary examination and cleared the backlog in the year 2013. It is also stated by the petitioner that the petitioner had received the consolidated marks sheet in the year 2016, and thereafter the petitioner approached the respondent university, seeking issuance of the degree certificate, and the same was denied to the petitioner, and accordingly, the petitioner has presented this petition. I heard Madam for the petitioner, and Shri Shama Nargun, Lana counsel appearing for the respondent number 3 university. Shri Reshma Ketil and a counsel appearing for the petitioner, invited the attention of the court to annexure K to the writ petition and argued that, the university itself has communicated to the petitioner with regard to the issuance of the certificate, and also she brought to the notice of the court that the similar brought to the notice of the court that the respondent number 3 university has issued the convocation certificate to the students who have cleared the course during 2008-2011 academic 11 batch of Bachelor of Science in Animation. Accordingly, she sought for similar relief to the petitioner. Per contra, Shri Kshama Nargun counsel representing the respondent number 3, invited the attention of the court to the circular dated 8/4/2021, as well as the 18th August 2021 issued by the UGC, and stated that in view of the information stated at 18th August in the letter dated 18th August 2021, within bracket annexure R11, the petitioner, the respondent university has told the degree certificate as the university was not as the UGC has stated that the penal action will be taken against the third respondent university in the event if the marks cards are released which are outside the territorial jurisdiction of the third respondent university. In the light of the submission made by the Lanark Council appearing for the parties, I carefully considered the writ papers, whereby it is not in dispute that the petition herein has completed the Bachelor of which course, madam?
BSc Animation.
Yes, again, Bachelor of Academy of Animation and Gaming AAG so and so course during 2008-2011 batch belonging to the 2008 and 2011 batch of the third respondent university. I've also considered the contents of the reply made by the respondent university to the petitioner produced at annexure K to the petition dated 20th October 2020, wherein the university has stated that, there is no impediment for them to issue the relevant degree certificate, relevant convocation degree certificate to the petitioner herein after obtaining the appropriate fees for the same. However, having taken note of the contents mentioned in the letter in the circular dated 8/4/2021, within bracket annexure R10 to the writ petition, R10 to the statement of objection, whereby the circular has been issued by the respondent university, issuing convocation notice to students enrolled on or before 2012-30. Taking into consideration the said circular dated 8/4/2021, I'm of the opinion that since the petition herein, had completed the course during 2008-11, I'm of the opinion that UGC cannot extend the UGC cannot penalize the respondent university if the university release the convocation certificate in favor of the petitioner forthwith. And in that way of the matter, the writ petition is allowed, the respondent 3 university is directed to issue the relevant convocation certificate as next one, and the migration certificate. And the migration certificate as sought for in the writ petition within 2 weeks, madam?
Very well, your lordship.
Within 2 weeks from the receipt of this order.
My lords, I appear for the petitioner in 20.1, my lords. 542.
Yes. What is this matter?
This matter pertains to the students of Karnataka State Open University. They're all the students of
Yes, madam.
technical students, my lords.
Diploma. You file objection. You file objection. Learned AGS seeks short accommodation to file statement of objection. Yeah, just after 2 weeks, can I say? 2 weeks. Just after 2 weeks. Let us will see.
Very.
Just after 2. Shri Krishna. Yes. One minute. Writ of mandament direct respond to approve accord admission of the petitioner 1 to 7. Admitted to 8 based on the permission granted by the University of Ayush. So and having received the admission and other fee as per. Yes. Anyway, you have a copy of 997. Admission approval for 7 so by the 7 so. And following the order passed by this court. Now they cannot say that have been approved for academic year 2021.
Central government's order, see.
Anyway, implement this order 7/10 to 22. Please sit down. Petition number 1 to, please sit down. Petition number 1 to 7 are pursuing the first year BAMS course with the permission of the Ayush, with the permission of the Ministry of Ayush, dated 17 to 2021, whereby the 54 admission to first year BMS course was accorded. It is the case of the petitioners 1 to 7, that they have been admitted to 8th semester college based on the NEET eligibility criteria. And as per the calendar of events issued by the respondent university, produced at Annexure C to the petition. It is further stated in the writ petition that the 8th respondent college, it further stated the 8th respondent college, 8th petitioner dash college, where the petition number 1 to 7 are pursuing their BAMS course, I paid the necessary fees for the same. It is the grievance of the petitioner that, the respondent university is not approving the admissions of the petition number 1 to 7, forwarded by the 8th respondent college, and as such, the present writ petition is filed by the petitioner seeking approval of their admission by the respondent college. The petitioners have also filed an application, enclosing the order dated 7/10/2022, issued by the respondent university, whereby it is stated that the respondent university, has approved the admission of the petitions number 1 to 7 herein in the eighth petitioner college for first year BAMS course in terms of the order dated 7/6/2022 in WP number 3808 of 2022. And therefore, it is contended by the Learners Council, Sri C.V. Krishnan, Learner Council applying for the petitioner, that having the respondent university having been approved the admission of the petitioners number 1 to 7 in the 8th respondent college as per A7/10/2022, the respondent university cannot turn around and deny the same to the writ petitioners students. Per contrast, Sri so and so Vaidya sought to justify the action of the respondent university. Having heard the Learner Council appealing for the parties, it is not in dispute that the petition number 1 to 7, having eligibility criteria, have admitted to the first BMS course at the eighth respondent college. I have also noticed from the letter dated 7/10/2022 issued by the respondent university, whereby it is stated that the respondent university has approved the admission of the petition number 1 to 7 in the 8th respondent college for first BAMS course for the academic year 2021. And in that way of the matter, I am of the opinion that the respondent university cannot deny the approval to the petitions number 1 to 7 in the 8th respondent college, having taken note of the order dated 7/6/2022 in WP number 3808 of 2022. And in that way of the matter, I'm of the view that the respondent university shall approve the admission of the petition number 1 to 7 admitted to the 8th respondent college based on the permission granted by the Ministry of Ayush, Government of India, as per Government of India dated 8/6/2021, produced at Annexure C to the writ petition. Accordingly, writ petition is submitted. Yes, sir. Eight petitioner call. Very good. Yes. What is this? Objection is filed. Objections.
The direction to file the notes
What is the? Just I want to know what is the issue involved in this petition?
This penalty imposed by the data.
Yes. Correct. Yes.
Section, but this kind of violation is initiated in the Constitution. Violations any other section, resident provision.
Yes. It should be always prospective in nature. Article 20. 20. 20. Exposed facto law. Exposed facto law. 20 class 1 article.
2016-17. The Act contained in 2017, they cannot be penalty in the year 1890.
It should be only in perspective. But any penal action, it should be always. That is a law. That's the Constitution says.
That is correct.
why I'm saying prior to the provision, when it came into force. Correct.
It says, but 2016 and 17, by April 2017, the academic year over. Plus, this is not only with respect to penalty, it's also
Irrespective of this.
it's of penalty.
No.
128 hours. Penalties.
But any action that you've taken in so far as, even if you excess fee, the institution has taken excess fee. It is true also. But that cannot be enforced beyond this provision. The date on which it was promulgated. 20 class 1, ex post facto law. So inserted means 22/4/2017 means, according to me, I think it should be 217 and 18. Yes, 4 April. No. Even if institutions taken excess fee. Before 22/4/2017, you have no right. But not issue. You can take action in furtherance only after 22/4 in the event if they have taken any excess. If you're ready, I can take it up. Both of you ready, I can take it.
This is
$230, but the 230. Tomorrow we have some matter. 230. We have continuously some other. Thursday ತಗೋಬಹುದು 2:30. Do one thing, sir. Even file it in the court. Better. That's the ex post facto law, I think. 20 class 1. List hard. Yes, hard the Lana senior counsel, she is Basuraj for the petitioner. Madam so and so for the Lana DG for some time. List up for further hearing on 2:30. One minute. Just 1 minute. Next P is challenge. 1 minute. P. Sorry. Yes, sir. Copy to the madam. Oh. No, ಮಾನ್ಯತೆ ಇದೆ. Recognition. ಮಾನ್ಯತೆ ಮತ್ತು ಸಹಾಯ ಇದೆ. That is a recognition.
Since from 83,
No. Now what is required now? 21, 22 have students or not? That's all.
teachers are every student. They are trying to honestly subsequent governments. To fulfill the merit, then they will respect.
Objections filed. No? Okay. Let us wait. Yes, sir. No. That you leave. Just you argue the matter. You're ready, I will take and take it.
Like in this case, annexure P,
Annexure?
annexure P.
Annexure.
Very
Just. Very, yes, sir. Reasons. 74. ಸರ್ಕಾರದಿಂದ ನಿಗದಿಪಡಿಸಿದ ಮೂಲ ಬೇಗ ಹಾಕಿಸಿರುತ್ತಾರೆ. ಓಕೆ.
ದೀರ್ಘಕಾಲ ನಡೆಯುತ್ತಾ ಪ್ರೌಢಶಾಲೆಗೆ ತೀವ್ರ ಅನ್ಯಾಯ ಮಾಡಿರ್ತಾರೆ. ನಮ್ಮ
Based on which order the government has taken decision? Where is that order? Then it is only a consequential.
This is consequential.
Where is that earlier order? Withdrawing the annexure or part 5. ನಮ್ಮ ಶಾಲೆಯನ್ನು 2017-18 ಸಾಲಿಗೆ ಮುಂದುವರಿಸಲು ಅನುಮತಿ ನೀಡಿದ್ದು ಶೈಕ್ಷಣಿಕ ಹಂತ ಮುಂದುವರಿದಂತೆ ಪ್ರಚಲಿತ ಶಿಕ್ಷೆ 8 ದಾಖಲಾತಿ ಮಾಡಿಕೊಳ್ಳದಿರಲು ಹಾಗೂ ಹಾಲಿ ವ್ಯಾಸಂಗ Why it was issued, madam? Just 1 minute. Why R5 was issued? No, just you read R5. I अनुमति नहीं. We are pressuring them. And on what basis you go to then 7/2/2018. 7/8/2018. You stated that you can so you have continued for academic years 2017-18 and the academic. Yes. Revive. Yes. Revive the strength of the students. On what basis the 7/2/2018 you arrive at a conclusion the school has to be? Where is that order? 7. Because if you look at prima facie, if you look at R5, in fact, you are pressurizing the institution to close it actually. Where is that report?
It's 12 hours.
No, you produced the student strength as well as the prior to. See, this is the order 7/2/2018. In 7/2/2018, the commissioner, the director had come to a conclusion that there is the strength of the school as well as it has to be closed. Kindly get that 7/2/2018. On what basis the 7/2/2018 order has been passed? Sorry. Leonard AGA is directed to produce the records pertaining to the decision taken by the directorate of product Shikshanala. That means that is a secondary education, dated 7/2/2018 with regard to taking decision to close the petitioner's school by next date of hearing. Let us 28. List on 28. List on 28. 25th the one. No, you will get it here on. Today itself. I only will by 2:30 will give you. No, by 2:30 I will give you. No, by 2:30 I will give you the order. Nothing. Let us take it up because otherwise SLC examination is there. Let us will have it on Friday, 25th. 25th. List on 25th. Yes, sir. Just one. So, Shirik, quashing the annexure J and H and J. Syndicates in its meeting at a result to reject. Yes, sir. Here. Endorsement, just 23,520.
There is no provision in the act.
By the university to the government. Under which provision Annexure H is passed? To give permission for affiliation to start BSc nursing course with an intake of 40 students in St. Joseph. On what basis the
There is no accreditation.
course for academic year 2021 as per the 167? Since the alleged proposal dated 2020, which is said to be under the consideration of the government, withdrawn from the government by finance. Under which provision that you exercise this for rejecting the proposal made by the university? Then university. Very good. Now, who is the answering party now? Government or the universities? Who is the answering party here? See, you made a proposal. When you have made proposal? For 2021 academic year. Where is that actually? Just 1 minute. Annexure D. Affiliation application to start fresh nursing course. Syndicated nursing as a result to recommend for fresh nursing course with an intake of 40 students. Academic year 2021. Once LIC report along with 20 was sent to the Secretary Medical Education. What medical education had taken decision in furtherance of the same? Annexure? Yes, you are requested. Since you have filed contempt, that's why they are not. Under which provision, madam, this order is? No, it is already proposal sent. Recommend for 40 students is recommended actually. Recommend 2021. Just you go to Annexure D. No, Annexure, just you go to Annexure D for a moment. It was recommended by the university. Where is that order? Where is that order? Where is that order? No, by Annexure D, it was recommended by the university.
Annexure J, the answer is there.
Yes, sir.
The subject is indicated in this meeting of 2021 as a result to reject the college. This plot was not sent. Either there is a reason assigned to us. They are not assigned any reason to the government. Once they pass the order telling that yes, it is result to.
How can you pass 2 orders? Petition, you are not receiving. You are applying for a BSc. Then it is. Okay. This hard copy. You get instructions from the university insofar as Annexure B and insofar as now it is Annexure J. Once you accorded permission and thereafter you refused. On what ground you refused? Despite you having the report relating to the feasibility or whatever we say, infrastructure. Not it.
Last case, not I was.
That's right.
Today, not been over.
Thursday, in between.
I'll saw a copy.
Good. At the request made by the Rana Council appearing for the respondent number 2, list on Thursday. Only thing is on what ground that you granted the permission and thereafter withdraw. For what reason that you have? Yes, sir. No, let us read. Just if it is required, I will. What's the fact, sir? Now, what is the matter? Like two you are saying? Just a minute. Okay. Now, where is that dispute? 70 dispute. Where is that order passed by the 32. Yes, sir. But this is impugned in this. Yes. What is it? Yes. On what reason it was? Apparent aware that appellant was acquitted in the criminal case CC number. Further in the dispute number 811, wherein you have challenged is a dismissal order before the respondent number 1. The award was passed in his favor. The said order was passed and no appeal has been filed. The appellant states that (33) 2013 itself. Club together and pass common order. Just 1 minute. He had entered over the case. Now, what has happened to the appeal filed by them? Their appeal. Huh? Which is that appeal actually? Just a minute. Appeal number 19 is filed by the society. Correct. Next, another appeal is NIMDU 84. 18. Yes. Your challenge which order? Annexure? Annexure B. 1711. That is under. Where is? Anyway, that appeal in the event if that is also pending, let KT shall consider the same. Common order. Because the appeal in appeal number 47 of 2019 filed by the society, which is the impugned order. Annexure? Oh. Dava 811 ante idu. Just a minute. No, you have been reinstated. So against this 22 to 2011, appeal number 47 of 2019 is filed.
And that appeal is taken for consideration. My appeal also will be considered for your appeal.
Yes.
But these are considered in the model because they have taken out the execution for implementation.
Against order date 17/11/2019, your appeal 84 of 2018 is. That both the appeals shall be clubbed together pass order. 48 minutes. Very good. Consequently, appeal 84 stand dismissed. Let the order passed by the KT shall. Under 118. 117. Let the KT shall consider, madam. Let the KT shall consider both the appeals. Two appeals are even your appeal still even it is still pending. Let the KT shall consider the same. It is before the same bench, sir. It is before the same bench in KT. Same bench. Yes, madam. Yes. 8 years. 8 years. Same thing will be applicable to the other even otherwise. Even if there is a delay of 8 years, 56 days. '84 of 2008. Yes. Same order will be passed. Can I pass order or senior in law? This is the thing. Both anyway, the petition and the respondent are pending, are the parties in mother appeal. Same order be passed. Yes, totally. In this petition, please note, the petitioner has challenged the order dated 31/3/2022, passed in IA number 1, filed by the petitioner in appeal number 84 of 2018 on the file of the Karnataka Appellate Tribunal, within bracket annexure A to the writ petition. To the petition. The relevant facts for adjudication of this petition are that. The petitioner has challenged the order dated 17/11/2009 passed by the first respondent number 1 in dispute number 2 of 2002-2003, wherein the respondent society has initiated recovery proceedings against the petitioner. Within bracket annexure B to the writ petition. The respondent authority by order dated 17/11/2009 directed the petition hearing to pay sum of rupees 7,54,405 with interest, and being agreed by the same, the petition hearing has filed appeal number 84 of 2018 before the KAT, in which there is a delay of 8 years, 8 and above, 8 and what's the delay? 8 years and 56 days. And the petitioner has filed an application seeking condonation of delay in IA number 1 under section 5 of the Limitation Act. The KAT by impugned order dated 31/3/2022, dismissed the IA number 1 filed under section 5 of Limitation Act, consequently the appeal number 84 of 2018 stands dismissed. Feeling agreed by the same, petitioner has presented this writ petition. I heard Sri S.K. Acharya, the counsel appearing for the petitioner, Madam so-and-so for the government, Sri K. Manjunath Rao Bhonsle for respondent number 2 society. Sri S.K. Acharya, the counsel appearing for the petitioner, contended that the petition hearing has filed dispute number 811 of 2003-3/2004 under section 71 of the Karnataka Cooperative Societies Act, within bracket hereinafter referred to as Act. And the respondent authorities by order dated 22/2/2011, reversed the order passed by the set aside the order passed by the respondent society dated 27/6/2003, and being agreed by the same, the society has preferred appeal number 47 of 2019 before the KAT, and same is pending consideration before the court. He further contended that the appeal, the petition hearing has challenged the order dated 17/11/2009 by the respondent authorities, whereby the respondent authorities has directed the petitioner to pay the sum of rupees 7,54,405 with interest to the respondent society in dispute number 2 of 2002-2003, against which the petitioner has filed appeal number 84 of 2018. The Sri S.K. Acharya submitted that the KET by order dated, which is that order that admitted by order dated 27/11 alla 32 irಬೇಕು ಅಲ್ಲ order dated by order dated 27/11/2018 admitted the appeal keeping open the issue relating to the limitation. However, despite the appeal filed by this respondent society in appeal number 47 of 2019, the respondent, the KTS passed impugned order which requires to be interfered with in this petition. Yes, sir. Let both the appeal will be considered together. Well, anyway, your appeal is also there. Yes, very well. Anyway, his sub is also pending. Your appeal is also pending. That the court will consider on merits both. Merits. See, yes. What about in your appeal? I think there is a delay. Yes, in your also 2011, the order is passed. Appeal is for 2019. There's also delay of 8 years. Only thing is, only two points. Either both the appeals should go or both the appeals should be heard. Even otherwise, delay, not on merits. Not on merits. Yes, that's. And she told him. She came Manjunath Rao Bonsle and a council appealing for the respondent society contended that there's a delay of 8 years, 56 days. So Manjunath Rao Bonsle, appearing for the respondent society, he said, submitted that there's a delay of 8 years, 56 days in filing the appeal, and the petition is not prosecuting the proceedings before the KAT regularly, and therefore having provided reasonable opportunity to the petitioner, the KAT has passed impugned order which requires to be confirmed in this petition. And AGA also supports the contentions, affirming the impugned order passed by the KAT. Having heard the Lana Council appealing for the parties, it is not in dispute that the petitioner was working with the respondent university and the respondent society by order dated 27/6/2003 dismissed the service of the petitioner, and being agreed by the same, the petitioner has filed and being agreed by has filed dispute as raised dispute as raised a dispute which was challenged before, which was challenged in dispute number 811 of 2003-4 before the competent authority by the respondent society, whereby the competent authority by order dated 22/2/2011, set aside the order of dismissal of the petition hearing, and as such directed the respondent society to continue the service of the petitioner. Within bracket annexure D, by order dated 22/2/2011, and the said order has been challenged by the respondent society in appeal number 47 of 2019, which is pending consideration before the KET. I've also noticed that, the petition hearing the respondent society has filed dispute in 2 of 2002-2003, and the competent authority by order dated 17/11/2009, allowed the dispute, and as such directed the petitioner hearing to pay sum of rupees 7,54,405 with accrued interest by order dated 17/11/2009, which was challenged before the KET in appeal number 84 of 2018. I've carefully considered the detailed order sheet produced by the petition hearing at annexure A to the writ petition, whereby the KET by order dated 27/11/2018 admitted the matter with keeping open the issue relating to the limitation. However, by impugned order dated 31/3/2022, dismissed the IA number 1 filed by the petition hearing under section 5 of the Limitation Act, seeking condonation of delay of 8 years 56 days. I carefully considered the reasons assigned by the petition hearing, seeking condonation of delay of 8 years 56 days. Is a full stop. On careful examination, the reasons stated by the petitioner would indicate that, the petition hearing was acquitted in the criminal case in CC number 412 of 2005, filed against him by the respondent number 2 society, and also it is stated that his counsel C.H. Somanathaya did not prefer appeal before the KET in time, and the Lana counsel appearing for the petitioner engaged therein was died on 30th March 2003 to 2030. Taking into consideration the fact that the petition hearing was acquitted in the criminal case, and the petitioner has challenged the order dated 17/11/2009, wherein the competent authority has directed the petitioner to pay sum of rupees, has passed an order for recovery of rupees 7,54,405 with the accrued interest. I'm of the view that, in the event if the delay is not condoned, taking into consideration the sufficient cause shown by the petitioner therein in the affidavit accompanying the application in IA1 filed before the KET, I'm of the view that the hardship would be caused to the petitioner herein, and therefore I am of the opinion that the order dated 31/3/2022 passed by the KT be set aside, and IA1 filed by the petitioner in appeal number 84 of 2018 is allowed, and the KT is directed to heard the appeal on merits and pass appropriate orders. It is also made clear that it appears that the appeal preferred by the respondent society in 47 of 2019 was not brought to the notice of the KT while passing the impugned order in appeal number 84 of 2018. Though the cause of action for the respective appeals which are arising out of the different the dispute are different and distinct. However, they both are one way or the other connecting with each other, wherein the surcharge proceedings has been initiated by the respondent society against the petitioner, whereby the petitioner herein was acquitted in the criminal case in CC number 412 of 2005, and that apart, the proceedings in appeal number 84 of 2018 was filed against the order dated 17/11/2009 in dispute number 2 of 2002-2003. In that way of the matter, taking into account, while considering it is a well settled principle in law that while considering the application relating to the condonation of delay by the authorities / courts, it is not the length of delay, but the cause of delay has to be considered. That way of the matter, taking into consideration taking into consideration the law declared by the apex court in the case of state of Nagaland versus Lipak 2015, 2005, yes, 2000 Lipak versus so and so. It is not the length of delay. Howsoever may be the length of delay, but if the sufficient cause has been shown by the authority, by the deponent in the affidavit accompanying the application seeking condonation of delay, it is the duty bound to condone the delay. In the instant case, the petitioner has the petitioner has stated that he has engaged the services of the council and died, and therefore the KT ought to have construed the delay. Very well. Very well. But till yes, yes, we will leave it to them. In that way of the matter, yes, that way of the matter, I'm of the view that the KT the KT ought to have liberally construed the delay in of the law declared by the apex court in the case of 2014 SC AR so and so, and pass appropriate orders on merits itself. On the merits itself. Let us on merits that we will consider. Merits. Anyway, it is closed. Sorry. In your allowing the writ petition, and in order to avoid further delay in the matter, and as the parties to the appeal are represented through their learned counsel, I'm of the opinion that the KT is requested to take up this appeal on
Yeah.
15th of December. Working day. 15th. Yes. 15th of December. 15th of without issuing further notice to the parties. Anyway, it goes. Sir. Continue of following the writ petition, setting aside the order passed by the KT on IA number 1 and remanding the matter to the KT for consideration of the appeal preferred by the petition hearing on merits, any further proceedings taken in the execution proceedings is so and so is set aside. Set aside. Let us will see. KT anyway, it will be taken up. KT will take it. Yes. Next.
I appear for the petitioner's counsel.
Yes, sir. Yes,
But this is a matter which is coming up repeatedly to
yes,
enable state to file their objections. There's no such urgency from the state's point of view. So you lots may post it for hearing after they choose to file their objections. The small issue is, Lords, whether after
2 weeks, sir. After 2 weeks, can I take it up?
I have no difficulty, but it is coming up without they taking it forward in any manner.
At the request made by the Leonard AGA, list after 2 weeks. Let us will see.
Obliged, Lord.
Yes. Fast over, man. Good evening.
Appearing for the petitioner, Lordship.
Yes, sir.
Lordship,
Yes.
kindly adjourn the matter, Lordship. By Wednesday, it will be.
So it's the second time I'm at the request made by the Leonard Council appearing for the petitioner, list after 2 weeks.
That's as lovely.
No representation on behalf of the petitioner. List after 2 weeks. Yes. That's against the order passed by the district court. Just what is the facts? Let us read it. Correct. Under 16 class 3 of the Act. Correct. So what is the award passed by the district judge? 1,50,000. Where is the finding recorded by insofar as the computation? 19. Paragraph? It's not 20. Page?
Page number 19 of the statement. Page number 20.
Right. 26. Yes.
So in the bottom, they want to
Since the ownership of the land remains with the petitioner, therefore 50% of the total market value. Therefore, diminution of land value is taken to consideration as diminution. So 50% has been considered. According to you, it should be 30%. So this court has held that as regards the diminution value of the land falling within the corridor. There also 50% was considered. I find that 30% of the market value.
The last line there.
Yes. So if you put 30%, then it comes around. If it is comes around. How much?
86,720.
86,070 towards the installation of cement shed. So remaining will be as it is. Only to that extent it is filed. What is the writ petition filed by the petitioner? Claimant? Padi. So Levisha case, that is the basis for all this. Levisha or something. Huh? But is by the Supreme Court.
No.
No. Which is that judgment which is pending consideration before. So 230. Let me will give an opportunity. 230 will take. 230 pass on. So, yeah, probably Mr. Jaganmohan is no. Matsudas, Mr. Jaganmohan. No more. No more. No more on that. Let us issue the court notice. We issue court notice. Let us will say, I will pass over. In the event if the Chandrachud will come. Huh? List up to 2 weeks. Yes, Mr. Shashidhar. So 30% is correct actually. Consistently, even afterwards, I think Virappa Saibrudu only.
No, this is
But normally 30%. Normally 30% will take it. Particularly. Because even the recent judgment seen 30%. Even otherwise, 30% is correct. No. This even the similar petitions, even in Kalburgi Dharwad, we have made it 30%. Livisha case and Supreme Court. We will make it 30% better. That is a law. That's a law on the point, actually. Let us see. Only when so far as that aspect. Remaining it will not be touched. Only in so far as 50%, it should be 30%. In Mikidala Agir. Only to that extent, instead of 144, it should be 30% under 86 extra barate. That's what will happen. The land is only. Maybe there will be some diminution. That's correct.
Yeah.
Consistently 30%. Consistently, if I remember right. Let us. We will make it 30%. Third. I will dispose of it 30%. Huh? No, only insofar as the last part of the order. Where it will come? Settled position of law. I know it is there, but it's settled position of law. You give me where it has to be increased. No, where just use menu. See. Go to impugned order passed by the Leonard district judge. Towards installation KV tower in the land, petitioner an amount of 6,000 is awarded. Because of sure increasement. Prospective image. No, the only the relevant period, the relevant aspect is in which period it has been done. This is then tower is it will open the Pandora of facts. That's a different only insofar as instead of 6,000 it may be enhanced little more. Little more I will pass orders. Let us switch. Told. Reasons to follow. 37. Let us switch. 38. Reasons to follow. This option had appeared actually. Pass over ಮಾಡಿ 230 ತಗೊಳ್ಳಿ. ಹೌದು. It's 230 can we? ಅಲ್ಲ ಅಥವಾ ಇನ್ನೇ ಅದರ No representation on behalf of the petitioner. Senior counsel Sri J. Kumar S. Patil appear on behalf of the respondent number 5. Respondent number 5. Respondent society. This next week and next Monday. Yes, sir. By the Assistant Commissioner and Maintenance Tribunal. Just a minute. Next year, Next year, fellows. Just 1 minute, sir. Just a minute. You are the son, sir. Oh. Take care, my father. Yes.
In fact, you are giving it was not wanted to be paid into. There's an interim of thereafter, after 1 year, it's still 11,000. Again, you are 13%. So, my curiosity.
A little more you have to pay.
And you realize you see the order. There is a huge spending.
Where is?
In the field of page 43.
43.
Otherwise, it's good. And my Assistant Commissioner has passed an order. And over the position of all of land family properties not come to beyond the property.
Just self-acquired property of the father. That could be read.
No, the self-acquired property of reduction. Land property in China. But even respondent brothers have filed a case. Plus, there's a partition here. Children also have filed. Still pending. The asserting whether it's left out of self-acquired property, it has to be decided in the suit.
Yes, sir.
The Assistant Commissioner automatically have passed an order.
Yes. Where, just a 1 minute. Where it is stated that these survey numbers are self-acquired. Sharjitavada Medicaid Council, Venkatarangaya. Where you are shown, madam? They are self-acquired.
Because it was a Gandhavata family, the Madhavasya is there.
Brothers, and that is Venkatarangaya and his brothers. In OS number?
OS pending ಇದೆ ಇಲ್ಲ.
OS pending ಇದೆ ಅಂತ ಅವ್ರು ಆಗ್ತಿದ್ದಾರೆ.
Yes. Anyway, it is not your property, sir, of course. Well, whether it's a self-acquired ancestral will be looked into later. Of course, right now, anyway, the brothers of the Venkatarangaya has filed a suit. That means, otherwise, it's a duty. It is a duty, sir.
The point is, respondent has put the Assistant Commissioner.
Yes, sir.
I have absolutely no given them in the maintenance, which are being paid, and not only what the all the
Yes.
apart from that, you please see, they have made a, any maintenance against not only children, it's a brother also. Why you should file a application against the brother? Because you are all in the joint family property, because it is father's property. And father died about 50 years back, it was the eldest person.
Yes.
It has come to his day. So, because of that reason, it was the joint family property of the brothers of respondent and the children of the respondent also.
Yes.
Respondent and the brothers, this is the joint position. So, they were all doing confusion operation.
Yes.
And that's why he has tried against the brother also, his own brother also has tried that.
Which is that OS? That is 343, na?
343 is right by three of
Just 1 minute, 1 minute, 1 minute.
three of 2017 is there.
3
Three of 2017.
here?
It's of the road. 3 of 2017 and 343 of 2015. Also, is by the brothers of the respondent. Other is children against the respondent. Partition. So this has to be decided there. So far as properties are concerned,
That has to be determined. On what ground the assistant commissioner has come to conclusion?
please see the order of the adjourned commissioner on my statement. I just read the short order.
I think 42 from the bottom. That is a finding. Yes, sir. Palakara portion. Anyway, to that extent, it will set aside. Of course, you cannot encumber or alienate.
He himself is encumbered the land. We have been paid the loans for the loan with the bank because it was in his name.
To that extent. How much now it is spent? How much now it is? Now it is?
Now we pay 13,000 rupees.
13,000.
13,000 rupees have been paid every month. Apart from that, we have given one house also for him to stay. And after we stay there, also
Just a minute. To that extent, I will set aside. To that extent, yes, since it is, sorry, reasons to follow. Writ petition is allowed in part. To that extent. Khata, since Khata is there. Even otherwise, even the title has to be decided in a school. Yes. Let us to that extent it will be. No, let us use next matter. Let us. Suffice. 2 minutes ago. Suffice. Yes, Rashid. Just 1 minute. First order appointing the fourth respondent. Fourth respondent. Let's say, Pesra of Ananta University. Who has passed in order?
Order to be passed by Mangalore Taluk.
A, B, C. Ultimately, which order actually? All the three orders. All the three orders.
That's 233.
233 annexure F.
Who is getting Thursday at all?
The Thursday beda, you are a beda. No, not this week. Next week, uncle. Let us will say next week. Date week. Okay. 30th. ಅವ್ರು ಬರ್ತಾರೆ ಅಂತ ಆರ್ಡರ್ ಮಾಡೋದು ಬೇಡ. Missed on 30th. Appeal for it. Senior citizens. Senior citizens. 39. List. Just 1 minute. Non-payment of court fee. You paid. Just 1 minute. Just one minute. Just 1 minute. None EGA except notice for respondent number 1. Nursing school, yeah, that. Nursing council and nursing examination board. Sumana Baliga for respondent number 2. 3 and 4 ge Yogesh D Nayak accept notice for respondent. Similar order madidella. You have a copy of the same. What about there it is intake of 60 to 90. Here also 60 to 90. No? In which petitions? 2, 1. One and two. 1 and 2. The next matter. 2. 2, 3, 1, 4, 6 same order. A non-compliance is you complete 1 week. In under 2, 3, 1, 4, 6 of 22 and a council appearing for the petitioner pleaded urgency in the matter and seeks 1 week's time to comply with the office objection. And 1 week is 60 to 90. That's all. No, not stayed. Not stayed. It is not stayed. Only insofar permitted them to take examination from 60 to 90. Not stay the same. 1 and 2 same copy. It will be very well. Yes. No, that we have not taken. 1 and 2 same order. Just same order. What is 3, sir? Just 1 minute, sir. What is the mandate director consider approve the admissions? This is also this is 23133. Allah 23133. 23133. Government illa idralli, party illa. State Diploma in Nursing Examination Board gara Yogesh Naik. Accept notice for respondent number 1. State Nursing and Paramedical Authority or Yogesh D. Naik accept notice for respondent. Very petition ಮಾಡಿದ್ವಿ ಸರ್ ಇದು entry matter is similar petitions whether entry matter. Where is that? ಯಾವ್ದ್ರಲ್ಲಿ? In which? The government ಇಲ್ಲ. Government is not the party. Correct ಇದೆ. Only Yogesh D. Naik is accept notice. Which writ petition, sir? Ardilana council appealing for dictator ಮಾಡಿಬಿಡ್ತೀನಿ ಬಿಡಿ ಸರ್. Ardilana council appealing for the petition. ಇದೆ. ಪಟ್ಬಿಡಿ ಸೇಮ್ ಆರ್ಡರ್ ಅದ. What about 23136? 1 even 23137 also. Mooru GNML. 23140 also same. Now we take it up the government matter. 23139. 23139. Just a minute. Not challenge the order. Just show the. Leonard AG, Madam, so accept notice for respondent number 1. Regulatory yaar bartara paramedical ge Yogesh D. Naik accept notice for respondent number 2. A similar order has been passed. Annexure. Annexure F. Annexure F. 48. 53 nalla. Yes. Page 53 nalli same order. Additional government to accept notice for correct. It is 23139. What about 23141?
So the same order.
What do you mean? 23141. Annexure E. 22/12/2020. Same AG accept notice. Yogesh D. Naik for R2. Same order alla? Same order. 6, serial number 6, 8, same order. 9. Yes. What is? 1 minute. Same order. Approve the admissions, same order be passed. Government accept notice, Madam Savancha, same order. 6, 8, 9 common order. Just to look into the next, how many students? Okay, still chamber. Still Then why?
The state also. They are considered society.
Why? Just pass me. Sorry. This is one more representation. Just I will look into it. In the event if it requires, I will post it. Also. Reasons to follow this.
ಇವಾಗ ನಮ್ಮಿಂದ ಆಫ್ ಮಾಡಿ ಲೈವ್ ಆಗಿ ಇವತ್ತು